Okay, that was for Ben Brooks.
All right. Well, it's still morning. Good morning, everyone. Today is Monday, April 12th, 2021. Sine die. I'd like to take this opportunity to welcome everyone to the House Economic Matters Committee. We have our last bill hearing, I hope, for the day, and that belongs to the good Senator Hester, excuse me. Welcome, and the floor is yours.
Thank you so much, Chair Davis and esteemed members of the committee. If I knew you guys had such great music, I would have joined earlier. Really appreciate it. And you're taking time to consider this important bill on the very last day of session. For the record, Senator Katie Fry Hester, and I'm here to present Senate Bill 902. If we can pass it before the end of the day, it will help put people back to work in well-paying cybersecurity jobs with an average starting salary of $89,000. Let me first describe the problem, and then I'll describe why this bill is a solution to the problem. The problem has two parts. Part one, you're aware of. For the past year, we've seen an unprecedented amount of unemployment claims. As of this February, we had 191,000 unemployed individuals in the state of Maryland, and many of them won't go back to work immediately or in their same jobs. Part two of the problem is that we have 22,730 cybersecurity job openings, and this does not include additional cyber and IT related jobs that are integrated into other sectors. For example, in Howard County, AT&T has 100 entry-level positions open. In Anne Arundel County, Bridges, a cybersecurity firm, has 40 cybersecurity positions open. In Bowie, Prince George's County, the Mill Corporation has another 30 jobs open, and some of those are in St. Mary's County as well. And so with unemployment at an all-time high and this extremely high demand for IT talent, it just makes sense to put those two together. So how does this bill work? How does it solve that problem? In the spirit of building back better, Senate Bill 902 attempts to help address the shortage of these IT workers in the area by creating a cyber workforce grant fund and program within the Partnership for Workforce Quality in the Department of Commerce. The bill has four components. First, it creates the grant fund and program within the existing Partnership for Workforce Quality in the Department of Commerce to simultaneously address workforce shortages in cyber and educational training programs. Second, it increases collaboration for industry-led planning. This is important because the Cyber Workforce Program will work with the Cyber Association of Maryland to facilitate a planning effort centered around the needs of our employers. Together, they will identify their common needs for hiring and the most cost-effective way to meeting those needs. The basic concept is let's identify the open jobs and train people who want them. The third thing the bill does is it promotes outreach to our unemployed Marylanders who are looking for new career options. It requires the Department of Labor to provide names and contacts to the Department of Commerce so that they can reach those people. Now, when those unemployed Marylanders receive information, they'll also find out about how to take a simple cybersecurity skills assessment test where they can identify if they as an individual have a certain aptitude for certain cybersecurity jobs. Colleagues, without training, some people are just good at this stuff. Natural gamers, for example, make natural cybersecurity professionals. The fourth part of the program is that it creates a cyber workforce fund, a special non-lapsing grant fund to be used for investment in programs identified through the planning effort identified with the industry. This fund will be used as a vehicle for future federal workforce dollars we expect to become available to the state in the near future. Colleagues, simultaneously, we have an industry grappling with workforce shortages who are eager to assist in more efficiently connecting Marylanders displaced by the COVID-19 pandemic with the right programs to find employment in this rapidly expanding field. With this legislation, we can facilitate our constituents' access to these high-paying jobs in the cyber industry and support the economic growth of the state of Maryland at the same time. For these reasons, I respectfully request a favorable report on Senate Bill 902. Happy to answer any questions.
Thank you, Madam Senator. I see Delegate Watson has a.
Yes, thank you, Matt. Thank you, Mr. Chair. First of all, I'd like to take the opportunity to welcome my senator to our committee, Economic Matters. It's good to see you as always. And I just want to ask you one question. How many jobs did you say are now open across the state in Maryland? for these kind of jobs, cybersecurity?
So there are at least 2,730 cybersecurity jobs open, but those are only the core cybersecurity jobs. So there's many more jobs that require cybersecurity skills that are also open.
I missed that number. Can you say that number again?
22,730 open jobs.
Right. And generally, what do they pay?
$89,000 for an entry-level salary. I was thinking about applying for one myself.
Pays more than your current job down here.
Thank you very much, Senator, and thank you, Mr. Chair.
Sure. Delegate Chi.
Good morning, and thank you, Mr. Chair. Welcome, Senator Hester. All I have to say is
You went
on mute.
Oh, I'm so sorry. Good morning, and thank you, Mr. Chair. Welcome, Senator Hester. All I have to say is I wish I had cross-filed your bill. We actually briefly talked about it. I cross-filed a couple of your other bills, but I love it, and anything we can do to not only grow our economy, but connecting people with job opportunities in the growth industries is really smart move. That is a win-win for everyone. So thank you for doing this.
Thank you so much, Delegate G. You're always a pleasure to work with.
You know, you're getting a lot of love here. We normally are a little rougher, so it sounds like you've got a winner here. Is there anyone else? If not, thank you so much. It was good hearing from you this morning, and have a great sine die.
Thank you so much, Mr. Chair. Thank you, members of the committee. I really appreciate squeezing this in.
All right. And with that, folks, we need to take a 5-minute break until we can hit 12 o'clock, and then we will go to voting list number 28. Voting list 28. No, we're going to start with, we're going to start with concurrences first, as I said earlier. So we've got a few of those to deal with, and then we'll go into the voting list. With that, thank you, guys. See you in just a bit.
We're supposed to stay on this link or signing again?
Yeah, no, stay on the link.
Yes, okay.
Video.
Where is it?
All right, guys, we will get this show on the road. I think we're live, so we're ready. Voting list number 28. We will open up with our concurrences. Robert, are you opening up for us, or is it Tiffany or Laura?
The only thing I have is House Senate Bill 65. The Senate has not concurred in the House amendments. There's one technical amendment that's needed. So you're going to want to appoint conferees.
This is really good.
They have,
Really neat thing to do. Hey, by the way,
Hold on, guys. Thank you. All right. So
they
this
have,
is more-
go ahead. They have Feldman, Augustine, and Hershey.
who did I say put?
Yourself, Delegate Dumais, and Delegate Brooks.
All right, this is actually pretty simple. I forgot to do something before that I need to do now. Is that correct?
Correct.
There was a technical amendment regarding,
It's the effect to date in the bill.
okay, so but it's gone, so we just gotta
Go through
the steps.
go through a formal conference.
Right.
We'll
but
accept the House amendments and then accept the additional amendment.
Everybody got it? If don't worry yourself about it. It's just procedural. We just got something and I missed it when I shouldn't have.
Likewise. So
All right, is there a motion on the concurrence? Or not to concur? The motion is,
Motion not to concur.
second.
all right, all in favor signify by aye.
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 Opposed, nay. Motion carried. We've appointed the conferees, so we will get this paperwork done.
thank you, sir.
Who's next?
I'll go. Can I go, Laura?
Yes.
Okay. So we have House Bill 1153. This was Delegate Adams' bill that exempts the State Board of Physicians from the requirement to approve the name of a professional entity whose members are licensed physicians. The Senate amendments remove a required notice to the Board of Physicians and allows MedChi to refer a name to the Department of Health rather than the Office of the Attorney General if someone thinks that there could possibly be something wrong with the name. So if you all agree with the Senate amendments, the motion would be to concur.
I would move to concur.
Second.
Okay, all in favor signify by aye.
Aye.
Opposed, nay. That motion carries. Motion to concur.
Okay. The next bill is House Bill 1288. This is an alcoholic beverage bill from Baltimore City. It restricts license holders in the 40th Alcohol Beverages District from selling alcoholic beverages before 10 a.m. or after 10 p.m. There are some Senate amendments, and the amendments authorize the board to issue a Class B D7 license instead of a Class C license in specified areas of Baltimore. And it establishes boundaries for the area for which the license holder in the 40th Alcoholic Beverages District may sell alcoholic beverages during certain hours. We received a letter of support from the delegation on these amendments.
Can you say all that again?
We received a letter of support from the delegation on the amendment.
I'm kidding. I'm kidding. All right, you said we got a letter, right?
Yes.
All right. Is there a motion to concur on that? Oh, come on,
Motion to
guys.
So
concur.
moved.
Motion to concur.
Second.
All in favor signify by aye.
Aye.
Opposed, nay. Motion carries.
That's all I have.
Laura,
Oh, I don't think I have anything, Mr. Chair.
are you sure?
Hmm,
You're right, we do. We have House Bill 581, the essential worker bill. So the Senate had added 2 amendments to the bill. The first is a clarifying amendment that the Attorney General's office recommended to clarify that the leave requirement is triggered to the extent funding is provided through the state budget or a budget amendment to compensate an essential employer for the cost of providing the leave. Apparently, there's a federal Medicare tax credit that could potentially have triggered the requirements in the bill. And the intent, I thought, was pretty clear that it would be an act of the governor to funnel state or federal funding to the employers. So that's a clarifying amendment the Senate added on the floor. And then in committee, the Senate Finance Committee amended the bill to remove the documentation requirement. So the bill would be silent as to appropriate forms of documentation when a worker puts in for public health emergency leave.
Mr. Chair,
Sure.
my question is, obviously the clarifying amendment I don't have a problem with. I don't know what the policy or procedure would be, because I would recommend that we don't accept the second amendment. This is 14 days we're talking about in the family healthy worker family leave thing. The family healthcare leave that we've provided, you're allowed to ask for documentation after the second full day of work. So we're now going to say that they can take 14 straight days without employer asking for any proof, and I don't think that's acceptable.
Let me tell you where I'm at. I agree with you, and I had a fit all weekend, but this is after I had a chance to calm down and think about it. This is where I think we are, because we have to get any concurrence with appropriations as well. If we want to see it passed this year, we'll probably have to take the amendment. If we're not worried about that, then we can, roll the dice and take our chances and see what happens. But I don't think it makes it through, back and forth conference and appropriation all in the next 12 hours. But that's a decision for the committee to make. Let me go to Delegate Chi.
Thank you, Mr. Chair. I was not going to say something after you said what you said, but I was going to agree with Chair Wilson because our committee worked on this extensively, and we gave thought to this particular provision, which is the second amendment that the Senate added. So my question, and just clarification, my understanding is our version simply says the employer may, right? We don't require employees to provide documentation every time. Some employers may not require. If they're a small business, everybody knows everybody. But in the slightly larger organizations, they may have a more formal procedure in order to make sure the shifts are covered and all those kind of things. So I'm empathetic to businesses that have to make sure that they can keep their doors open. I think we are justified in doing what we do, but I also heard what you just said about last few hours. So I'm kind of conflicted on that.
Delegate Adams, Delegate Chakoudian, and then Madam Vice Chair.
Thank you, Mr. Chairman. And then, of course, I would support the subcommittee chair's position on this. The concern I have is any employee who, if we actually get to the point where we're using this leave, an employee, I would think, would jump head over heels to demonstrate to the employer, here's my reason. I can't imagine a scenario where an employer, frankly, would abuse the privilege. If somebody has legitimate reason for leaving, verification, I believe, is very important. But again, going back to what happened with COVID last year, if this bill was in place, don't you think that an employee would be very happy to say, for example, my child, has COVID and here's some documented proof. I'm going to need to take the next 14 days off. And I believe that an employee in good faith would want to do that. So then it begs the question, well, if we get rid of it, why? Who are we protecting at that point? And I think it's asked and answered. We'd be protecting only those folks that would seek to abuse the privilege. And last comment, and I know that's a pretty harsh statement, but I believe that to be on balance what would happen. We'd be only protecting those that would seek to work around it. But remember the sick pay legislation. I mean, there's verification in that after a certain number of days. So I think subcommittee chairs, right on this. I can't speak to what's going to happen on the last day of session, but I didn't vote for the bill on the floor, but part of me feels like this is part my baby. When we did this bill, you and the subcommittee chair gave me far more discretion to work on this than almost any other bill that we've had in my 7 years. And I thought we struck a more than reasonable balance. And the Senate, on the other hand, I think waited to see what our work product looked like. And I'm not sure that they, and I've got to say this with respect. I mean, because I wasn't standing there watching while this decision was being made, but I mean, we were balancing a lot of interests during our subcommittee work that, Pam, Veronica, Seth, Mark, myself, CT, we put into this. So a part of me feels like what the Senate did was kind of worked against what was a fairly good work product coming out of our subcommittee. Thank you.
Delegate Charkouti.
Thank you, Mr. Chair. I'm sorry, my internet is sort of coming in and out. So Laura, can you just clarify, did you say that it removes any requirement for documentation, or it removes a list of what would be acceptable documentation? What exactly does it remove? I think
It strikes the provision of the bill that would have authorized an essential employer to require an essential worker who needs public health emergency leave to provide documentation. And then there's another provision that's struck that says that if a worker fails or refuses to provide the documentation, the employer could refuse to pay the worker for the leave. And then there was another provision that required the Commissioner of Labor and Industry to adopt regulations regarding acceptable forms of documentation. So the Senate removed that entirely. So there's no reference to documentation in the bill now.
So an employer could still request it, but an employee could not provide it and still access the paid leave. Is that the idea?
This would be, I guess, ultimately a question for the Department of Labor in interpreting the bill. The bill would be silent as to documentation, but I would think that they would say by striking documentation from the bill, there may be legislative intent not to allow an employer to require documentation.
Okay. Mr. Chair, I would go with your suggestion. I think that there's a lot of work and a lot of really good work that's been done to get to this point. And so I would support the idea of moving it in the time that remains without trying to change this, and possibly coming back next year, seeing if with more time it's possible to adjust it.
Madam Vice Chair.
Well, there's actually another wrinkle, and it is true that the subcommittee did yeoman's work in getting this to a place that I think was, even if the Delegate Adams, et cetera, didn't vote for it, I think there was a comfort level in the process and a comfort level in, sort of that we had a good product for a future, for this pandemic now, but also for future. But here's the wrinkle. This weekend, I've received emails from the advocates for the paid sick leave suggesting that that entire section should be stricken. Now, literally this weekend is the first time they contacted me since the bill was finalized. And in fact, now Twitter has multiple people saying, you know, Kathleen Dumais passed 581 without any of the paid sick leave. They would rather it come out and that we address it next year. I understand the timing. Whatever the committee wants to do is fine with me. If we don't concur, perhaps we can address what they want. If we do concur and they don't like it, we can fix it next year. But you know, like I said, I wanted to throw that out there so everyone is aware, because if we concur, I'm sure I won't be the only one that hears that this is, you know, they think that we are doing harm to the sick leave if we, I mean, honestly, the way the subcommittee did it, I thought it was important. The chairman and I talked about the fact that this at least leaves a door open, you know, so that we can work this through if we have such pandemic or whatever. But I just wanted to at least put it out there that that's what I am hearing from those advocating for paid sick leave.
Delegate Wilson.
Thank you, Mr. Chair. Laura, I have a question. In that bill, one of the other things we allowed for the business owners to set, employers to set a policy to ensure that the abuse of the sick leave wouldn't occur. Isn't that correct?
Yes.
So how does this in juxtaposition to that, how would this work? Or does that get stricken?
No, that part remains in the bill. So that's in a construction provision. So it says this section may not be construed to prohibit an essential employer from adopting and enforcing a policy that prohibits the improper use of public health emergency leave, including prohibiting a pattern of abuse of the leave.
Right. And since it's only 14 days, I'm Mr. Chair, you know, I'll follow your lead without a doubt. I get very frustrated because the Senate does this to us all the time.
Mm-hmm.
And then we have to go, if we want something or we get nothing, you know, and the advocates, it's like, I don't know what else to do. I thought we worked very hard, and this is not about my work product or my baby. This is on pure policy. This is on what's important, making sure we have something set out, and it's already a precedent that you can ask for documentation after a certain number of days leave. So my worry here is I understand we have to go through approach, Mr. Chair, and again, like I said, we will definitely follow your lead on this. I feel like we're being held hostage again. And this happens all the time. And so I know Delegate Charkoudian brought up about, let's something's better than nothing. I disagree fundamentally. This was a very good work product. They were nitpicking at last minute. And whatever we do, they're going to be angry. Nobody's going to be satisfied, which means we probably made a very good work product. But it seems like it's very frustrating to sit here and do all this work and have them nitpick, find one thing and say, well, if you don't take all of ours to do what we want, then none of your hard work passes. And again, I know you know the game, not the game. I know you understand the way the game better than I do, the game. But if there's anything, I guess my question is, tell me how I'm wrong. How is this not a game? And how are we not capitulating unduly for basically no reason other than being petulant?
Let me come back to that. I'll answer your question at the end, but let me from the others, and then I'll double back and give you some extra. Let me go to Delegate Turner, then Delegate Watson, then Delegate Adams.
Yeah, Mr. Chairman, I know we need to follow your lead, okay? It's a good thing, but I just wanted to let you know how I felt, and I'm with the vice chair on this about the paid sick leave. I'm getting phone calls myself, okay? This is a tough bill. We work very, very hard on this bill, and for letting the senators right now at the 7th hour here, the last hour here, to come and strip things out of this bill, I just don't think it's fair. I'm willing to go along with everything that my subcommittee chair and all of us worked hard on. I'm willing to compromise, but this is a big compromise for them to come in and strip all the things out of this bill that we work hard for our members. I just don't think it's right. And I just want to let you know how I feel about it, Mr. Chairman.
Delegate Watson.
Yes, so the issue of documentation, I mean, is it really too late? I mean, we do have 12 hours. And maybe we should send it back and say, no, this is not something we can support. I mean,
Let me get back to you, Delegate.
yeah, sure.
Delegate Adams, then Delegate Crosby.
Thank you, Mr. Chairman, for a second bite. It'll be the last bite. You know, let's go back to the philosophy of your bill from the very beginning. We have essential workers. We define essential workers. We also define essential industries that have to operate during the most difficult times. And with this simple, what seems to be a simple amendment, what you're doing, I think, and it's not you, it's what the committee would be doing if we accept this, is you're saying to these essential industries that you will likely not be able to perform the services that are deemed essential because we're giving broad authority rights to the worker to just leave without a verifiable reason for leaving. So think of it, and I go back to poultry because that happens to be the industry that matters very much to me. Could you imagine having this sort of catastrophic health emergency occurring this past summer with this in play, and say one of our local producers simply not being able to process poultry? And I'll go back to what I said the very first day at the very first work group, which is we went to grocery stores, my wife and I. We're a family of 5, and it was not easy at the early stages to be able to walk into a grocery store and buy protein, buy the basics. And, food manufacturing is essential. I'm using this as an example. There are many other industries that are also essential, but let's try to acknowledge the nature of the bill and what we're trying to do. We're trying to make sure we have a state and frankly, a country to come back to when the health emergency is gone. And this sort of amendment in and of itself creates such a challenge from a business standpoint. To simply not have workers would be untenable. I mean, it would be impossible to manage. My small business theoretically might be able to get through 2 weeks, but could you imagine a manufacturer being out of the ability to perform for a 2-week period, all at the same time when their inputs, and I'm thinking back to poultry, the chicken coming into the processing facility. What do you do with that for 2 weeks? It's just, and those are real stories, not in our industry, but in, the Ohio, and I'm thinking about, just different food inputs where they weren't able to process at the speed they were getting the raw material in. And it's just on this one amendment, I just worry. I worry because we are in this bill trying to protect the worker. I think we are, even with the verification piece. But we also are helping our state and our country survive a catastrophic health emergency. That's the balance that, CT subcommittee struck here. And it was not an easy balance, because I know this is one of the biggies that we spent a lot of time talking about. It had to be, because it was a core part of what happens when somebody's sick in a facility. Do you want them there working? The answer is no, you don't. But you also want, as an employer, to make sure that you can still operate. This bill, as it came out, struck the appropriate balance. And boy, I'm pretty passionate about it. And I'm sorry that the Senate, Senator Augustine, and you, Mr. Chairman, this was priority legislation. I would have a hard time believing, if we sent this back with respect, that we couldn't find agreement on this particular matter and stand by the many hours that we put in to try to make this a workable bill from a industry standpoint. And now I'm wishing I actually voted for it because I'm at a disadvantage. I'm advocating for a bill that I didn't support on the floor. I've got to reconsider in my future years what that looks like when we're having these kind of discussions, because I want to be heard on this one, and I think I am. But anyway, thank you for the second bite of the apple.
Delegate Crosby.
Thank you, Mr. Chair. And just looking at the hands, I think I'm probably last. And so I just wanted to follow up on what Delegate Wilson and Watt said. So what if we all vote no on this and then it goes back to the Senate? Is it just do we all put our mouth guards in and go at it? Like, I mean, what does the process look like if we oppose this?
This is what I would suggest. And that's why I wanted to go last on this. And I actually texted a couple of folks so that they would join on because I wanted this conversation to be heard. I sort of, had a fit over the weekend when I found out what happened. Here's the thing. Although the Senate put it on, I don't really blame the Senate per se. This was one of the advocacy organizations, quite frankly. I mean, let's just put it out there. And Delegate Wilson, you actually used the right term, game. And I say in this way, because without getting into too much detail, they're looking down the road at other stuff. So the concern was this would set a precedent for something else. And of course, everybody knows the game better than we do, how it works and how it's played and so forth. I wish some folks could join us at these tables and see it's not as simple as we think it is. The assumption could only be that, we'll get it on in the Senate and then the House will just recede. And where I lost my temper at was because I know you jokers and I knew it wasn't going to be that simple. I knew it. I don't come meet with you all for 5 or 10 minutes, a couple of times a session. I mean, I'm with you all for hours. I know I got a pretty good feel for you all at a certain point, and I knew this was going to happen. All right, now that I've had my second rant, this is what I would suggest, because I was willing to back off. Like I said, I know a lot of hard work was put into this, and I didn't want to see it go down. And I'm not saying that it necessarily has to go down. What I'm saying at this point is that we really can't ask them to recede either because of that technical amendment. If they recede, I don't think they can recede off one and not the other. You recede off everything or you recede off nothing. Right. So the only option then is to go to conference. Now we can talk about that at that point. I mean, the conferees, we can probably look to maybe go potentially to that compromise language that Delegate Dumais mentioned about stripping the whole section in its entirety, and maybe maybe letting the department do regs or whatever we I don't want to try to come up with the compromise right here, but the point of it is, and the reason why I was concerned per se was that in addition to what we have to do, and it has to be read back across the desk, assuming the Senate is inclined, then they'd have to appoint conferees. We get it done. The paperwork has to go through, the amendment office and all that kind of stuff. And then the Senate, not the Senate, appropriations, they've got some role in there somewhere in terms of something because it was jointly assigned. So it's another step, and it's just, it's a calendar thing. I don't think it's that complicated. I think we can get the thing worked out, but it's all the steps that still have to do. And the later we get into the evening, the breaks start becoming less frequent, and quite frankly, the will starts to die out after about 7 o'clock. The will starts to die down a little bit, historically speaking. But in any event, I wanted to answer everybody's sort of question that sort of posed it to me, and what I would suggest at this point, based upon how you guys are feeling, because I'm not gonna ask you all to do something that you're not comfortable with. We will just not to move not to concur and ask for conferees and see if we can get it done.
Mr.
I think that's good, Mr. Chair.
All
Is that a
right.
motion to concur, Chairman?
Second.
Motion not concur.
Motion not
To concur.
Second.
I second that.
All right. Did anybody else? Delegate Watson, were you waiting to speak, or was your hand left?
No, sorry.
All right. All in favor signify by aye.
Aye.
Opposed, nay. All right, motion carries. All right.
Are we still doing a
We'll
filibuster?
get to work. Huh?
I feel like this is a big filibuster session.
No, we got to vote.
You need
Yeah,
to,
now let's
The
actually,
first of
Mr.
many.
Chair, you would need to appoint conferees, right?
yeah, Davis, Dumay, and Wilson.
Okay.
Who's the chair?
You are. Actually, you are. I'm not gonna be running around. The chair means you're responsible for the paperwork.
Oh, shit.
That's all it means.
Works for me.
I was gonna do it until you asked the question, wise guy. So now you're
It was meant to be a joke.
See what it got you? All right.
Way off base.
Let's go to
Way off base.
guys. Let's go to Senate Bill 834, please.
Senate Bill 834 is the bill that makes various definitional changes to the employment discrimination statute. Among the changes, the bill alters the standard for harassment to include sexual harassment, defines sexual harassment, and makes a related definitional change for a training requirement for state employees.
Hey, Mr. Chair, I have a question.
Yes.
Laura, would this be similar to the, I'll use air quotes, training that we received this year? This the kind of training that they also have to receive?
Yeah, this is for all three branches of government.
Right, to get kind of what we all had to sit through this year?
So this isn't setting up a new requirement, it's altering the definition of sexual harassment that is a part of the training.
And does that go along with, I don't know, Title VII as it already stands, or is it broaden it?
So what the bill is doing is it's changing, in the state government article, Title 20, Subtitle 6 is the employment discrimination statute. And so in the employment discrimination statute, it's changing the definition of harassment and defining sexual harassment and including sexual harassment as falling under regular harassment. And then it's in the state personnel and pensions article that has the training requirements for state employees. It's cross-referencing the state government article so that the definitions would be in sync.
Okay, and those definitions, are they in sync with what's currently in federal law, or is this something, again, I'm just trying to find out, because after this last training we went through it, the sexual harassment was so incredibly broad that it could really mean anything, anytime, anywhere. And I want to make sure we are not putting our state employees to that persecution.
My understanding is that many states have gone with this definition. I think around 20. I'm trying to find it in the testimony that we received. Well,
And it's more just,
20, but it's the idea really is in the specifics. Harassment currently says oral, written, or physical conduct, whether or not the conduct would be considered sufficiently severe or pervasive under precedent applied to harassment claims. We are trying to make it very clear. Harassment would be unwelcome and offensive conduct, which need not be severe or pervasive. So it's simplifying it, and it's much more specific than what is currently in law. And then somebody would have to make the determination based on the totality of the circumstances, determine that the conduct unreasonably creates a working environment that a reasonable person would perceive to be abusive or hostile.
Okay, no, I
I
just,
think the standard and the definitions are just much cleaner than existing law.
no, that's fine. I just want to make sure we weren't doing what we had to experience a few weeks ago. So I got it. That's
No.
fine.
No,
Thank you.
so I would move
Uh,
favorable. And just so you're aware, JPR passed it unanimously, and not that this is always persuasive, but so did the Senate.
I'm sure.
I understand, I'm just saying.
Second that motion.
I think Chris has his hand up.
Yeah.
I got it. Thank you.
Sorry.
Delegate Adams.
I've got one clarifying question. I want to make sure I got this right. This only applies to state employees. This is not a private sector bill whatsoever. Is that correct?
That's
No, I think-
incorrect.
Yeah, I was
That's
gonna say, I think
incorrect.
this is
Yeah, so
statewide, yeah.
Everyone.
I think the important part of this bill is not the training part that we've been discussing. It's actually changing the underlying law for what is considered harassment in an employment discrimination lawsuit. Or
I actually think it clarifies it for employers almost more than anyone else.
It does.
And, you know, that's the reason why I think it's important. And it
So
was
the-
the Senate JPR committee that added the concept of a reasonable person, which is a good legal standard.
So,
the only thing I was going to add, Delegate Adams, is that the employment discrimination statute applies to employers with 15 or more employees.
all right, so the follow-up question goes to what Vice Chair was talking about, which is the definition of need not be severe or pervasive.
Mhm.
Of course, I'm an employer who's trying to interpret that.
That's out.
Well, I have
It
the
says-
reprint. It says unwelcome or is the unwelcome and offensive conduct which need not be severe or pervasive. That's out.
No, that's in.
Well, unwelcome and offensive conduct is in, that need not be severe or pervasive.
Yeah, so but which need not be severe or pervasive isn't, Bill.
Yes, it is.
Right, okay,
You're
so
right.
so as an employer, I'm trying to interpret what need not be severe or pervasive, which I'm not an attorney, but basically that means anything. I mean, there's no, that is a standard, but it's not a standard because it can be completely innocent and non-pervasive, and still, in the eyes of the beholder, be unwelcome and offensive. And so as an employer, how in the world? I mean, there's.
Well, if a claim is made, then that is, but first the employer has to make the determination. And if it has to rise to the Commission on Civil Rights, then it moves there.
I'm just talking about from a practical application of words I'm seeing as a layman. There's no, the standard is that there's no standard to make a claim. That's how.
I don't think the old language had much of a standard, whereas I think this is clear. It's unwelcome or offensive conduct, and it doesn't have to be severe or pervasive. Where previously it was oral, written, or physical conduct, whether or not the conduct would be considered sufficiently severe or pervasive under precedent applied to harassment claims. I don't know how that's any clearer than this. This, I think, is simple. It's unwelcome or offensive conduct.
So, Madam Vice Chair,
Mhm.
why is this better?
Because I think it's easier to describe something that's unwelcome and offensive than just oral, written, or physical conduct that may not be sufficiently severe or pervasive to be harassment.
It narrows it down.
I think it really does.
Yeah. I know what you're thinking,
You know,
Chris.
we can agree to disagree, but I think it's
No,
narrow.
that's why I'm not talking. It sounds like it's.
I figured. Okay.
This is not an easy one for me to, I mean, this is your Cindy Die bill. The last day of session.
Let me go to Delegate Bouts then.
Thanks, Chairman. So do we have, was there any testimony from the Chamber of Commerce or NFIB or any of the business groups saying that they want to see this change that would help?
The Chamber of Commerce submitted written opposition testimony, as did the Washington County Chamber of Commerce.
Okay. I was going to make a joke and ask if it applies to bars and restaurants.
I'm sure it
Might be a
doesn't.
problem. Delegate Adams, if you look on what's page 3 of the reprint, look at lines 11 through 14. I think that also helps clarify how it would be applied.
Mr. Chair, when will this be reported out?
Sometime,
Today?
I don't know if it would be because of what has to occur. I don't think it would be within our first meeting.
Okay.
So I don't think we'll be on the floor that long unless something's changed. I think we'll be on the floor. Well, let me not act like I know what's going on. I don't think we'll be on the floor very long.
Okay.
So it would come up when we take a break and then go back the
All right. Because I just wanted to, I want to get the book and talk to Laura about it before we get to the floor.
Okay. Let me go to Delegate Aaron's, Delegate Queen, Delegate Fisher.
Council, what is a reasonable person? What is that?
Not a Republican.
It is.
That's why you're so well liked, Delegate Wilson.
Oh, he's liked? I'm sorry. My
I
mistake.
actually think that maybe the vice chair or Delegate Wilson could speak more to it because it's more of a practitioner question, but reasonable person standard is a common legal standard that would be interpreted through case law, what a reasonable person would perceive to be abusive or hostile.
I think that's a good description. In law school, they talk about it being the little person sitting on your shoulder.
That's fine. Okay. I
Right
guess my
from
point
wrong.
is I sat in this training this year and I would probably make a motion, we make this into a study because what we went through that was sexual harassment training, which I appreciate the thought and I understand it's real, it's out there, but it turned into, and I think some of us on this committee were there, it turned into something that it was so vague and ambiguous that everything we said was sexual harassment. And I don't know that that's really the case. And I think if we want to make this just harassment, period, that's what we're really looking at when we start doing these bills. And harassment, as far as CT making a comment or me making a comment about the little curl coming down his head with his hair, that could be construed as something that's wrong. And him making a comment about a Republican considered wrong. And I think, we're kind of maybe taking something that is very serious that does happen in our workplace and we're making it so broad, we can't really determine. And I don't know how a reasonable person, if that's that little guy on my shoulder, is coming up with something that this is sexual, not sexual, it's personal, it's not joking, it's not this, it's not that. And I think you ruin careers and you ruin lives with some of this stuff. And I don't think this should be taken without a real hard group and somebody with some, I don't even know the word, would look at this type of bill and study it and come up with something that's definitive. I think if you would poll the General Assembly on this training we just went through, I'm not so sure, other than if you could take your name off of it, I'm not so sure you'd get a review that was anything. And it was very, very tough training to go through. And again, I just think this is very serious. Like this into a study. Wouldn't you agree, Madam Vice Chair?
Well, all I can tell you is that a reasonable person is not overly sensitive. It is a.
I guess I'm not reasonable right now because I'm overly sensitive about what's being said here.
I wasn't suggesting that you were.
No, and I wasn't taking it that way, but see what I'm saying right now?
But it
I
is,
just thought it was
sort of,
reasonable that
it is a
wasn't
legal
sensitive.
standard that has been used in multiple sorts of cases, whether it's, harassment or any sort of employment discrimination and,
And I understand that. I just think that this is so broad and so vague
But
that
if you look at the written testimony, there's a lot of good written testimony. And,
I have looked at it and I've looked
favorable.
at some of it that's not favorable, but I appreciate it.
That's right. There's
Tell you
only
what,
two that weren't favorable, right?
Let me jump in and get these last three folks so we can move on this piece. Delegate Queen.
Thank you, Mr. Chairman. I just wanted to comment that coming from a corporate management background, we dealt with this in late 80s and 90s. You'll get through it. You'll understand it. It needs to be done. And I think we've already moved favorably on there. Thanks a million.
Delegate Fisher.
Doris, just really quick for council. Is there a House cross file to this?
There is not.
That's what I thought. I just wanted to make sure because I was looking for the testimony. So on this particular Senate bill, did the trial lawyers write a letter of support?
No,
They didn't.
not that I
Interesting.
have. What I received was testimony from the Women's Law Center of Maryland, Maryland Coalition Against Sexual Assault, Maryland Pro-Choice Maryland, and then the opposition testimony from the Washington County Chamber and the Maryland Chamber.
Got it. I guess the trial lawyers figured that it was going to pass. Maybe that's why they didn't write a letter. But but thank you. I appreciate that. It's hard to get a lot of this testimony last minute. So thank you.
I think it is available, hopefully, to you all.
Yeah,
on
it
the
is.
floor.
It's online. On your floor system, you can get to
Well,
that.
I'm Kathleen. I'm well aware of that. My point is that just the time issue. You know. It's
Okay, I understand. Sure.
Delegate Watson.
I just want to echo what Delegate Dumais said about an established legal basis and what Delegate Queen said about this is not new in the business world. And as tough as that training might have been for you, it's a lot tougher when you're actually subjected to this type of harassment. And so we all have to stretch a little bit and take what we can out of these kind of things. And the bill is pretty reasonable if you look at it compared to standards across industries. And so I definitely would support the movement of the bill.
Mr. Chair.
All right. Yes.
I apologize now for bringing up the training because I realized and I saw Laura's look. I'm sorry, Laura. The training that I was mentioning has very little to do with.
Nothing.
So to all my colleagues, I apologize. That training was inherently garbage. I do believe, and I will go on the record as saying that they made everything that it's anything harassment and sexual harassment. So I want to make sure that we don't conflate the two here with what Madam Chair and what Laura's talking about is just a legal simplification of a standard that allows employers like myself to understand what sexual harassment is versus the vague standard we had. It's more akin to federal law now. It's a lot more clear. It has nothing to do with the training we received. I'm saying that because I know on the floor, we are going to have to deal with that, climb that mountain, because right now everybody's a little raw after what we had to deal with. But that is nothing to do with this bill. So I apologize for leading that rabbit hole.
All right, guys. I think we got a motion and a second.
We do. Motion's favorable.
Favorable. Madam Vice Chair.
Yes.
Delegate Brooks.
Yes.
Delegate Fisher.
No.
Delegate Queen.
Yes.
Delegate Turner.
I'm on mute. Yes.
Delegate Rogers.
Yes.
Delegate Carey.
Yes.
Delegate Jackson. Delegate Jackson's excused. Delegate Tippy.
Yes.
Delegate Mouts.
No.
Delegate Wilson.
Yep.
Delegate Impalaria.
No.
Delegate Branch.
Yes.
Delegate Valderrama.
Aye.
Delegate Walker.
Yes.
Delegate Chee.
Yes.
Delegate Adams.
No.
Delegate Aaron's.
Yes.
Delegate Fennell.
Yes.
Delegate Charkoudian.
Yes.
Delegate Howard.
Yes.
Delegate Crosby.
Yeah.
And Delegate Watson.
Yes.
Motion carries. Senate Bill 911, please.
Senate Bill 911 is the bill that increases the limitations on the amount of compensatory and punitive damages that may be awarded to a plaintiff in cases of unlawful employment practices. It increases the caps, which are broken down by employer size, and includes what Senator Smith referred to as an escalator clause, which is a 5% increase on the caps each year. The bill also increases from 2 years to 3 years the amount of back pay that a plaintiff may be awarded, and increases the limitations period for when someone may file from 2 years to 3 years. So someone would have an additional year to file a complaint.
Madam Vice Chair.
I actually think that the escalator clause should come out and would make a motion that we remove the escalator clause or make an amendment to just remove the escalator clause.
Let's start there. All in favor of that signify by aye.
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 Opposed, nay.
Then I would move the bill as amended.
Mr. Chair,
Yes.
before we do that again, because this is not just a statute of limitations bill, and the escalator clause is obviously horrible. What was the other parts of this bill, Laura? Because it's not just a statute of limitations, is it?
Or it's not. So for unlawful discrimination cases, it increases the maximum amount of compensatory and punitive damages. So in the bill text, you can see that there's, it's under the current law, the cap is imposed based on employer size. So it is increasing the caps for each of those brackets. And then the bill is also increasing the amount of back pay that a plaintiff may receive. Currently, it's up to 2 years of back pay. And so this bill changes it to up to 3 years. And then it also allows for an additional year for filing the claim.
And was there a crossfile on this bill?
No.
I just don't feel, Mr. Chair, I don't feel we have enough time. This is a huge thing we're doing here. I think it's a very big thing we're doing here to have this limited amount of time to discuss. I don't know what the hurry is or what the rush is. Laura, do you know what the impetus of this bill was? Did something happen, or is there why we're here right now at the last minute doing this?
Well, to be fair, the committee's had the bill for a minute. It's just the committees, I have had a lot of work, so I put the bills up when I'm ready for them.
I understand that.
And so this bill, I believe, was put in part because the caps have not been increased for some time.
Okay.
And I'm not as
As to
concerned.
the other changes.
Yeah.
Go ahead.
That's right. I'm not as concerned so much with the caps. I mean, if you wanted to sort of leave the caps where they are or whatever, that doesn't bother me. Moving the statute of limitations is really just making it in line.
That's fine.
As a result, that does mean there would be 3 years back pay instead of 2 years, because the
The 3
statute of
years is
limitations is
fine.
currently 2. But it is
That's
just lining the statute of limitations up. But
yeah, that's why I didn't have a problem with that part of it. Obviously, I'm a big fan of statute of limitations increases, but I thought that 3 years is what we do for most things anyway. I didn't know the other part was in that bill, and I don't know if that's something I don't really believe. I don't know, and I would move to strike that from the bill. I don't mind increasing the statute of limitations, but as far as increasing these payments, was there a lot of opposition to this bill?
I believe the only opposition was a letter in opposition from the chamber. There wasn't a lot of testimony on this one.
Right. It seemed like it just kind of snuck through. And this is a much bigger bill than I thought it was. I must have missed something.
yeah, and with the caps, just so you know, I did go back to look to see when's the last time caps were addressed. And for what it's worth, it was 2009, which is the reason why I think the escalator clause was a problem, which we've stricken. And I'm not wedded to the increase in the caps.
I would,
whatever
like
the
to make a
committee would
motion.
like to do about that. You want to leave the caps where they are?
I would like to make a motion that we strike the increase in the caps, leave the caps where they are.
Before we follow through, let me see where Delegate Adams was going, then we'll come back to your motion, Delegate Wilson.
Thank you.
Mr. Chairman, can we do his motion and then I'll talk? Yeah.
Okay. All right. Does anybody want to speak to Delegate Wilson's motion?
I'll second it.
All right. If not, all in favor signify by aye.
Aye.
Opposed, nay. All right, that carried. Now Delegate Adams.
All right, so Laura, with this amendment, so it's still 3 years back pay? So give me an example. We have an employee who gets paid, let's say $60,000 a year, and there's an unlawful employment practice. I can't think of an immediate example, but is that $180,000 in back pay for that employee? Is that what we're implying for a violation?
I believe so. Because I'm not a practitioner, this is definitely not my area of expertise, but the statute says in addition, the current law says, in addition to any other relief authorized by the subsection, a complainant may recover back pay for up to 2 years preceding the filing of the complaint where the unlawful employment practice that has occurred during the complaint filing period is similar or related to an unlawful employment practice with regard to discrimination and compensation that occurred outside the time filing for a complaint. So this bill is changing that from 2 to 3 years. So may recover back pay for up to 3 years preceding the filing of the complaint.
All right, so we're not
Just
adding.
because the statute changed. If
Right.
passed it, it's because the statute of limitations changed. Because you
So,
can to 3 years instead of up to 2.
right. So Laura, it's already in statute. What you're saying is it's now going 3 years instead of 2. And these caps apply to what, if you don't mind me asking that?
The caps are for compensatory and punitive damages related to an discriminatory employment practice.
All right, so let me ask you then, but on the same example, 3 years, 60,000, it's 180,000. You're saying that on top of the 180,000, there'd be punitive damages possible? Is that so? What that would look like financially?
So it's my understanding that with this type of case, it has to start with the Commission on Civil Rights. So it's an administrative process initially, and then potentially it could go to court. And so what the statute says is that, looking for the punitive damages section. The
It's
punitive
page 2.
damages would be only in court, not at the administrative level. Trying to find where it is in the bill.
Is that because
And
this has a
page
private right of
2,
action?
Line 19.
Sorry, Madam Vice, what did you say?
I think it's page 2, line 19.
Yes, it has a private right of action.
Yes, that does have a private right of action. There's specific language about punitive damages, but
Punitive was on.
I'm sorry, Laura, let me just stay. So does the current law have private right of action? Okay, so we're not changing. I'm just trying to figure out where the changes are. That's the.
It sounds like, is it just going from 2 to 3 years at this point? Is that the only
Correct.
thing left?
That's it. We
with
narrowed everything else out.
so the committee has voted to strike the increases in the cap on damages and the sort of the escalator clause that it would increase automatically each year. So what would be left in the bill now is that the period for filing would be extended by 1 year. So you'd have 3 years to file. And in turn, you would be entitled to receive up to 3 years in back pay.
Yeah.
Right.
Delegate Aaron's.
Laura, if this were the state of Maryland and they got caught in one of these suits, how does that work for the state? They have their own lawyers. Is that what we'd do?
AG, for whatever the department is, would handle it in all likelihood.
Yeah, the fiscal note says potential significant increase in general and special fund expenditures for litigation expenses and payments of awards in cases involving unlawful employment practices. So the state appears to be covered by the statute as to how it would be litigated.
Covered by taxpayer dollars that would pay for the defense or the rebuttal of this. I was wondering, has anybody ever talked about the size of the company in one of these bills? Because when you're dealing with a big corporation versus a 5 or 6 man shop, these huge numbers, a huge discrepancy in numbers, and the 2 to 3 year terms. When we talk about extending that or not extending that, that to me is really problematic for a real small company, and extending that.
So this lady who reached out about, she was like the property.
It may work well for a big corporation, but it doesn't work well for a let's say a small bar or small restaurant, because those numbers could be just destroying the company.
I think that the intention of the entire bill, the way it's written prior to this, the law would have the same problem with. Going from 2 to 3 years doesn't really make that much of a difference. I mean, financially, yes, there's more, but I think the problem we're talking about is with the law in general, which is going to, regardless if this bill passes, is going to be there.
Wow. Okay. I'm just saying, if we could put something into, we're extending it right now. We're going to extend.
Yes.
That is a save. That is a plus in my world, because I'm not dealing with the big numbers. I don't have corporate lawyers on retainer. But I certainly a bigger court. You're your own attorney. Other companies have corporate attorneys on retainer, so it's not a big dollar for them. And that's why I'm saying, if we could put a size limit on something like this, that would be something would actually help a small business owner, in my opinion.
Gotcha.
So can we?
I don't know how you put a size limit on discrimination.
Right.
Well, and I
They're-
guess
they're-
that just as a reminder, this statute applies to employers with 15 or more
15 or
employees.
more.
There you go.
Right. It's already limited by the small business little thing that we throw in for everything.
Oh, but your local landscaping has 15 employees.
Well, right. And it was 30, 60, 100. We got to find the line. Well,
Just to point out that, so the damages caps, we didn't walk through them, but the caps depend on the number of employees. And so it's.
All right, guys, Laura, let me jump in. I was hoping to get through it, but we've got to get to the floor. And when we're done, we got to come back, guys. We will
thanks, Aaron.
the list right where we left off, but these bills I've got to get through. We'll go through that. So we got concurrences and 834. I'll see you guys on the floor and we'll be back as soon as we can. All right.